Assalamu alaikum wa rahmatullahi wa barakatuh, my dear brothers, friends, viewers, Ikra TV. Welcome to another edition of Real Talk. I'm your host, Iqbal Bana. I come into your homes every week in, week out, most weeks, trying to bring to you some issues of interest, of importance to our community, try and bring issues that people need to be aware of and need to factor into their lives. As I've said, we've done programs on Islamophobia, on education, on health, on COVID, for example, we did quite a bit. On Muslim foster caring, the need for more and more Muslim foster carers because of the number of Muslim children who are in the care system, etc. And previously, I've had a guest, a legal person, and we've talked about some of the issues around family law, issues around wills, and what happens in the event if you become ill and you cannot have, you don't have the mental capacity to make decisions about your well-being, about your health care, also about your finances. If you, Allah na kare, but if you end up in a situation where you suffer a stroke or whatever it is, and you have lost the ability to communicate or to make decisions, then who is going to be responsible for making decisions on your behalf? Have you made provision to make sure that those people who are left behind have the power to make some decisions on your behalf? I remember a case where somebody suddenly became ill. They ended up on a ventilator. The family wanted to switch off the ventilator because they're seeing that that person was suffering, and the doctors refused to switch it off unless somebody had the power to make that decision on behalf of that individual. So we want to talk about this, and we want to talk about both finances as well as health. And I have somebody with me as my guest. She's not a stranger here. She's been here on a number of occasions. And I'm really deeply honored that she's given me her time to join me today to come and share her knowledge and her experience around these very complex and legal issues. So can I welcome my dear friend Nasreen Karim to this program. Nasreen, thank you for coming. Thank you for giving up your time. I know you're a very busy lady. By the way, she's a legal practitioner. She has an office in Bradford, and her company is called Platinum Partnership. And as I say, she's been on my program and other programs before as well. So welcome to the program.
Thank
as
you
I
for having
say,
me.
a lot of people we don't realize the implications of what could happen to them in the event that if they suddenly become ill and they don't have the ability to communicate. So they become unconscious. They may be on a ventilator, and they may have some desires about what they want to do with their finances, their property, for example, or their medical care. But unless somebody has the power to make that decision, nothing can happen. And sometimes it can end up in a court of law, and it could drag on for months and years. So can we, obviously as a legal person, and the other thing we want to talk about is the importance of wills, because I don't think many people understand the necessity of putting a will together. Because if you die without a will, it really could complicate your whole estate, and you could have real problems in the family, and that could be really messy for the family at times as well. So let's talk about, some people call it lasting power of attorney or living power of attorney. Let's talk about the medical side of it first, please. So what's your opinion on this? Why is it important? Why is it necessary that people should have these?
Okay, so let me just go back 25 years. I've been practicing law for 25 years.
Wow.
I'm always really busy. People are buying houses, businesses, selling. They are building and acquiring wealth, and they want to better their lives, their children's lives, their families' lives. So we're all busy trying to buy and improve and better ourselves. But the one thing that we as a community, this is especially bad throughout all the different communities, but especially within our community, we're so busy building because we're immigrants. We came here 50 years ago with nothing. We're so ambitious about building an empire and a life for ourselves that we don't really think about the most important things. For example, making a will, having a lasting power of attorney, having to possibly go to the court of protection. So if you are incapable of making a decision, who's going to make that decision for you? We forget that. So you'll go to a janaza. How many janaza do we go to? All the time. We prepare for that. We prepare for death. We know who's going to do what. But when it comes to sorting out your affairs legally, you know, everyone's kind of scratching their heads and thinking, well, we don't quite know what to do. And yet some of these things are very, very simple. So for example, let's take a will, for example. £200-300 plus VAT, you make a will. What's a will? It's a set of instructions as to what will happen if you pass away. You'll have property, you'll have car, jewellery, whatever it is.
Any asset, basically.
Any asset at all. You should know what you want to do with it. So for example, if you're married, you would possibly want to leave it to your spouse. And generally, husband and wives come to us together and they have mirror wills done. Right. So a mirror will is, it's identical to each other, but just the other way around.
So if one passes away, it automatically goes to the other.
And then the wife will say the exact same thing. And then if they both pass away, what should happen, which children, especially in our community, lots of parents want to leave the gold to the daughters, they want to leave property and maybe money to the boys. So there's lots of different things.
So, I mean, just on the will, I mean, obviously some people might be interested in looking at Sharia compliant wills.
Yeah.
Now, do we have such thing as Sharia compliant wills, and if they are, do they have a legal status then?
Yeah, of course. So
because this, you know, in Sharia, a boy would get a greater share than
and a third to the daughter instead. Well, you can easily reflect that in the will.
Right.
So a will are a set of instructions, your instructions.
Right.
If you want to give 2/3 to the boy and 1/3 to your daughter, that's completely acceptable. Sharia law is law. So if you're a Muslim and you want to abide by Sharia law, then your express wishes in your will, which are your instructions, are that 2/3 to my sons, 1/3 to the daughters, and there are calculations around that.
Oh, yeah.
So 100% you can have a Sharia compliant will. Some people don't want to do that.
Will that stand in a court of law? If say one of the daughters says, "No, I'm not happy with this. Right? This is unfair."
A will is a will.
So a will would be take precedent.
Yeah, a will is a will.
Right.
Those are the express instructions from the person making the will.
Right.
And if they want to exclude a party,
Right.
they may have an estranged partner or child or whoever, and they want to exclude that person, they can exclude that person.
Right.
Now, if going through probate, that person then wants to litigate and wants to be included in the will and takes this matter to court, then fair enough. So it doesn't matter whether that's a normal will or a Sharia will, it's up to that party to make an application to court. But a will is a will, they're your instructions.
Right. So whatever the person's instructions are, that will stand in a court of law. But in case somebody challenges it,
it can be challenged.
It can be
All
challenged.
wills can be challenged.
Right. Okay. So it can be challenged, but you hope that nobody would challenge it anyway.
You'd
But
hope.
I know, we know precedents. We've known about cases where people have challenged it.
Yep.
And, you know, and some cases they've won, most cases they've lost. But unless they have a genuine reason why, you know, they're challenging it, the chances are very limited.
Yep.
You know.
So does it make a difference whether it's a Sharia will or a normal will? They're your instructions. If somebody wants to challenge them, they can do. But it's the same for both.
Okay. So we'll come back to the wills. Like you say, they're not very expensive.
No.
You know, you can go to a lawyer, any lawyer, you know, and get those written up. And some people, you know, obviously they do it themselves. Whether they, you know, those, as long as the wording needs to be very carefully worded, I presume.
Well, I wouldn't say go to any lawyer. You'd have to go to somebody who's a wills and probate specialist.
Right. You need a specialist lawyer.
Ideally, just to be on the safe side, because there are lots of tax implications as well. So you want to get the best advice you can.
Right. Oh yeah, because there will be some capital gains tax, I presume, for the inheritors.
There'll be inheritance tax, capital gains tax. There are lots of tax implications as well. So you need to go to somebody who knows what they're doing.
What's the threshold for capital gains tax or the inheritance tax at the moment? Because the government looking at raising that to over £300,000 or something
well,
like that.
CGT is in the process of being changed. The inheritance tax levels increase, or should I say decrease. So they fluctuate. So I can't tell you what the level is right now.
Because at one stage they were talking about £1 million, and I know at the last budget there were some changes. I'm not very familiar. Inshallah, maybe if you know we do this again, we'll provide you proper figures. But I think there's a limit. If your assets are beyond a certain figure, then inheritance tax comes in.
That's right.
And you know, below that, you don't have to pay any inheritance tax. But you may be liable for capital gains tax. Maybe, I'm not sure. But that's something we might get an expert accountant to come and talk about.
It's a tax specialist.
The whole thing is about wills and the need for people to make sure that they have a proper will, because you know, you make the decision while you're alive and you have got the capacity who you want to inherit your properties, your assets, whatever it is. As Nassim says, some people want to leave their gold to their daughters and their properties and cars and money to their boys, or they can give some money to charity. And Islam allows you to give 1/3 of your assets away while you're alive. So you can do that. And you can also bequeath stuff within your will. So for example, in my will it says, after I die, after all the payments for my funeral costs, etc., have been paid, whatever has been left behind, X amount can go to this charity, that charity, and whatever is left after that, it goes to my inheritors. And you can do that, can't you?
Yes. Again, your instructions, whatever you want to put in your will, are your specific instructions to be followed by the executors once that person's passed away.
If anybody wants to ask a question around these issues, please feel free to ring in. Our phone number, as you know, is 01274 214 299. We'll be happy to try and answer some of your questions, or you might want to share some experiences that you may have had around these issues as well. So can we come back to the living power or lasting power of attorney? Now this is something, as I said at the beginning, and you alluded to as well, is in the event that a person becomes incapacitated, i.e. they cannot make a decision themselves, this comes into play, doesn't it?
Yeah.
So around medical care, what are the sort of intricacies about this?
Well, one thing we've got to be careful of is there's a lasting power of attorney, and the person who is giving away the power has to be fully compos mentis.
Yes.
They have to be able to understand what they are doing. So there are two distinctions. A lasting power of attorney is made by somebody who knows what they're doing and understands their rights and is capable of making decisions.
Right.
Okay. That will then come into play once they've lost capacity.
Right.
So I can enter into a lasting power of attorney today, and there are two types. One is financial, one is for health. So I can enter into one today. I am of sound mind. I can direct who I want to act as my attorney. So you have these done, and then if in 5 years' time, if I'm unable to make my own decisions, then whoever I've appointed makes those decisions on my behalf. So we have health and care lasting power of attorney.
Right. Yeah.
And you will appoint an attorney, or it could be two.
You want to show it again to the camera? I mean, you won't be able to read it, but this is the documentation. And you can access this information on the government website as well. It's freely available on the government website, and you can get all the information that you want. Yeah. But as I say, it's a very important document, so I'll let you carry on.
Yeah, absolutely. So with the healthcare lasting power of attorney, if somebody who's now unable to make decisions, they're in hospital, changing the medication, or if somebody's on life support or anything else, anything to do with when a decision has to be made regarding their health or even care. So this may not be a deathbed situation, even regarding care, you would have to appoint somebody who's going to make those decisions on your behalf. It could be absolutely anything. But until you've appointed somebody to make those decisions on your behalf and you're mentally unwell now, those decisions are very, very difficult to make. More often than not, you're left to the hospital doctor
the medical
or nurse,
experts.
the medical experts to make those decisions on your behalf, but they may not be the decisions that you wanted or your family wants. So you would then appoint an attorney to make those decisions on your behalf. That's what the healthcare power of attorney is for. Really important, and you can have more than one attorney to do that. So if there are two, it's really then important for those two attorneys to make sure that they reach an agreement in their decision.
A joint agreement, yeah.
Yep. So they're not conflicting either. So that's the healthcare one, and then you have the financial decisions, which is this one. And again, you make this whilst you're of sound mind, because you can't enter into a lasting power of attorney. And that's the important point, isn't it? That's the important point. You have to be of sound mind. You have
to be, as they say, of sound mind. Now, how does somebody prove that they're of sound mind? Because they're going to fill them in themselves, I presume. Or get somebody to fill them on and sign up.
I get my clients to come to me to fill these in, and then if there's any doubt on your client being able to give instructions, you've got to refer back to the GP to make sure that person is able to instruct you. So if you have any doubt at all, so lots of people don't.
Do you see any coercion going on sometimes?
I will only see that client on their own.
Right, okay.
I will not see a client who's giving a lasting power of attorney with their spouse, with their children, because unfortunately there is a lot of coercion.
Right.
And I know families where elderly people are being bullied into signing these or being bullied into transferring properties.
Right.
Lots of people nowadays want their inheritance whilst the parents are still alive, and there's all sorts of conflict. So there are so many things going on at this moment in time that you've got to be really careful. So with this, I will speak to my client on his or her own. They have to give me instructions. If I think that that person isn't able to give me instructions, if they're confused, if I think they may be suffering from dementia, I cannot enter into this.
So we've got a call waiting. Somebody's calling in. Assalamu alaikum wa rahmatullahi wa barakatuh. Please give me your name and where you're from, please.
Wa alaikum salam. I'm Mrs. Ali and I'm phoning from South London.
MashaAllah, Mrs. Ali. Thank you for calling.
Your program is very good, very good.
Thank you very much.
Yes, I hope that you will do another one to do with how to contest a will, and that would be very interesting too. The lady's just been speaking about if the person is too ill. Who decides whether a person is too ill to write their own will, or someone has to act on their behalf? Like you mentioned. My father was bullied very much while he was ill, and my sister and I thought of taking my brother to court afterwards and saying that, he'd bullied the father to take most of the inheritance while my father was alive. He was on morphine, but we thought that was a good enough thing to say that he wasn't in the right state of mind. What is the condition that has to be apparent, visible, to be able to say that this person is not in a fit state of mind to be able to make a decision?
So you want to know how could you prove that the person was not in a right frame of mind or was conscious
so that
sufficient
it doesn't happen to someone else in the future.
Exactly.
Me.
No, it's a very important point, Mrs. It's a very important point, Mrs. Ali. And as Nasseen says, that there is some coercion going on, and there's evidence of their children bullying their parents into doing what you say your brother's done.
Not always bullying.
Sometimes
it's just emotional blackmail. It's over-the-top love and fake, sympathy with them, and lies and promises to say that, Daddy, I'll do this, Daddy, I'll do that, I'll share it with the sisters. But once Daddy's gone, nobody's, nothing is on paper, nothing has been witnessed by anybody. Even if it was witnesses, it's just hearsay. Some of them passed away. So, in our case, we decided not to pursue it because in the end we would have probably got nothing. But while I'm on air, I would also like to highlight that in my own experience with my husband, we made an Islamic will. And we had very good Ferrani Taylor solicitors who were very educated in the whole matter. But when we tried to get other people to do it, we came across the problem that the wife only gets 1/8 of the husband's property, but in English law, the wife gets half or maybe all of the property. So this is one of the biggest reasons why many women will not allow their husbands to write a will. There is so much bullying in that area, up to the point where women are saying, I'll leave you, or, they get the sons and sisters or the daughters on board, and everybody's like, no, but what is mum going to have? So, yes, well, my question for myself is, what am I going to have then? If my sons are going to get the house, like the will says, my husband's leaving the house to them, I get 1/8. Obviously, I won't want to take it from them because they'll be needing the home, and they'll by that time probably, hopefully, be married and have children. But with the way the market is going, and the young people are struggling so much to buy their own property, parents need to write wills and leave their children something. But I think the very best thing to do is to give it while you're alive. Give it while you're alive and avoid the inheritance tax, avoid the other taxes, avoid conflicts. And in my case, I would like to know that when if I'm fortunate enough to be alive while my husband has died, and I get
Inshallah, may Allah give you both.
Homeless.
Yeah, both. May Allah give you long life.
What would the state do for me?
Yeah, and I'll come back to that. You make some really, really important points. both in terms of what's happened with your father and your brothers and sisters, and then about moving forward under Islamic law. A wife gets 1/8 of the estate, etc., etc. I mean, there is a thing called property trust. We'll come back to that if we get time, which is something that might be of interest to you. But I mean, in her Mrs. Ali's case from London, she said her brother almost sort of coerced the father, or emotionally coerced him into living the property to his name. Now, obviously, the sisters decided not to pursue that in a court of law. But is there another way, they could have protected that property and had a share in it, other than go to a court of law and contest it?
Yeah. So there are a few questions there. One of the questions was, how do you know whether somebody can give instructions or not? And with that, you have to take instructions from the person individual. And these aren't visible signs of incapacity. You've got to be able to look and try to understand what the person giving instructions is saying and doing. Can you remember? Is he repeating himself? Is he giving mixed signals? Is he giving contradicting instructions? So all these things.
Is that why you specifically meet with a client who's making that lasting power of attorney on their own?
On their
own. So
you
can make that assessment.
Yes, and if you have any doubt at all that that person isn't able to give proper instructions, then you have to revert to the doctor to see if there's any sign of any sort of mental illness, whether it's Parkinson's, dementia,
if somebody,
or anything else.
let's say in their situation, maybe I'm surmising here, maybe the brother did so in partnership with a lawyer, and the lawyer had not actually followed the rigorous sort of assessment that you do, for example. Are there any grounds for somebody to complain then?
Of course. So if a solicitor hasn't done his checks and somebody comes along and said, well, hang on a minute, my father has dementia, there is no way he would have been able to give these instructions. So why has a will been executed in this way, or a power of attorney executed in this way? And then that firm of solicitors can be reported to the Solicitors Regulation Authority, who will investigate.
Right.
So it's not an easy case of, well, I have a friend, I will do this. No, because that solicitor's reputation, livelihood is at risk if he does something knowingly like that. And then going back to having a fair split of assets, time after time after time, I've seen this situation where there will be one member of the family who will take everything, and the father will sign over property during the lifetime. On death, that can be challenged, but you will have to have some evidence that the father wasn't able to make decisions, or he was coerced, and you've got to be able to prove that. It's a lengthy process, it's litigation, it's very expensive. So in order to do that, you must have some evidence.
I presume that's why Mrs. Ali said that the sister decided not to pursue it, because they felt that at the end the lawyers will take all the money and they'll end up with nothing, which is true, and the lawyers would take the money.
Yeah, expensive, lengthy, you have to be able to prove that, and it's very difficult to prove. So yes, ideally, let's have the father splitting assets whilst he's still alive. Or the other alternative, when we're talking about mothers, what's the mother going to be left with? One easy resolution to that is, if the property's in the father's name, add the mother on.
So
you can have up to 4 people named at the land registry. So in order to safeguard the mother, because I've had instances where there's been a father has one child, daughter, and the daughter's husbands, brothers, nephews have all come along and said that they own a massive share of that property, which isn't very fair. And then they will throw out some Islamic text somewhere when they've done the Sharia calculator on nephews can, brothers, cousins, sons can. And when you look at that, and it gets very confusing, and then that person isn't left with anything. But if you have your spouse added on to the land registry deeds, that's a really safe way of making sure that the spouse or the mother is entitled and gets what she should receive.
And do you find that in our community, particularly the very traditional communities that we may have, who came here in the 60s and are still following very traditional rules, that the majority of those people still have a single person on the property register?
Absolutely, yes.
And is that why some of these problems occur?
Yes.
Right?
So the property's in the husband and wife name. They may be in the 60s
just the
or
husband's
70s.
name.
In most cases, they are still in the husband's name.
Right.
And then you've got to go through probate because
Yes.
the wife wasn't on. So I'll give you a really easy example. Husband and wife are named at the land registry on the title deeds, on the register. Husband dies, you produce a death certificate, the house is in the sole name of the mother.
Automatically transferred.
Yeah, automatically, you don't need to do anything. Very, very cost effective. If the property is in the husband's name only, then you've got to apply for probate.
Right.
And did that person die leaving a will or die not leaving a will? So you're going to have to apply for probate, which can be £1,500, £2,000, and you have to make an application to probate just to rectify what should have happened first time round. So my advice to couples especially is, if there is a husband and wife, and they are elderly, ask for the wife to be put on to the deeds. It just saves so much time and money and headache afterwards. That's one quick, easy way of doing that.
Well, Mrs. Ali, I hope that answers part of your question, in the sense that just to safeguard your sort of living accommodations sort of for the future, that you need to make sure that you are, and I'm probably sure you are, that you are both jointly named on the title deeds of the property. Then some of those anxieties and worries might be overcome. But if you want to follow Sharia law, obviously, then that can follow after your death, in my view, and maybe our Mufti Sahib can answer that question at some time. Now, as I say, some people use Sharia law for their own advantage, don't they, at times?
Of course, it depends what the calculation is.
Exactly,
Might
yeah.
be more cost effective for them
So,
to
I mean,
do that.
your brother may
Profitable.
not answer to you and your sister in this world, but I'm sure on the day of Qiyamah he'll have to answer to the greatest authority of all, our Maker, Allah subhanahu wa ta'ala. Maybe Allah, give him some hidayah. But yeah, I mean, so coming, in terms of, we digress from the financial to the financial matter in a way, property. In terms of medical healthcare, I remember there was a case not so long ago involving an English couple where the husband and wife had discussed what they're going to be doing in the event of one of them becoming ill. And the husband fell ill, ended up in a coma, and the wife said to the doctors in the hospital that, his wish and desires was to switch off the machine if he'd become sort of, what you term as a vegetable. And he didn't want to stay like that for the rest of his time, whatever that was left to him. And the family could see that he was being kept alive and he was not comfortable. He was finding that process very, very difficult. And the family were finding it very difficult. So that the family asked the doctors to switch off the ventilator. And the doctor said, no, we can't. Possibly because they didn't want to face any litigation sort of moving forward. And this dragged on for quite a while, and she ended up in a court of law. And because she did not have a written lifelong power of attorney, the court decided in the favor of the medical profession. Again, to say that medical profession were thinking that there was a possibility that he might be revived. But it went on for a year, and then eventually, he did pass away. But it can be that complicated and that difficult. And just imagine the trauma that the family would go through. Would you want to see your loved one suffering that badly? So this medical power of attorney is very, very vital and important, isn't it?
Well, there is a section on that subject
All
alone.
right.
So Section 5 of the Lasting Power of Attorney for Healthcare refers to life-sustaining treatment.
Right.
And it says in here, you must choose whether your attorneys can give or refuse consent to life-sustaining treatment on your behalf. Then it gives examples of what life-sustaining treatments are, so care, surgery, medicine or other help from doctors that's needed to keep you alive. So for example, a serious operation, a heart bypass, an organ transplant, a cancer treatment. So there's a whole section dedicated to just that, because it's that important.
Right. And remember, whoever you nominate, as your attorneys, you need to have total faith and confidence in them. You need to make sure that they themselves are somebody that you would trust with your life, basically, because that's what you're doing, to make sure that they will make the right judgments. They don't have to be your children. Preferably there should be more than one person, and at least two people. Am I right?
Ideally.
And the two people you should have total faith in that they will make the right judgments. And I've decided to put two people. One of my nephews is a mufti, and one of my nieces is a doctor, and I've got sons. So they want to make sure that they realize, Allah bachaye, if anything happens to me, then they will make decisions on my behalf if I end up in a situation where I cannot make a decision myself. Similarly with my finance. So if we move on to the finance section, obviously people will have money in their bank accounts, they'll have assets in their property, as you said, they'll have maybe gold, they may have shares, etc. Again, is the same principle applies, I presume?
Similar, so the financial decision-making last of power of attorney is a little bit more general.
Right.
So for example, you have an aunt, for example, who may be immobile or doesn't speak English, for example, and you need to access her bank accounts. You would need a lasting power of attorney to deal with her financial affairs for that.
Right.
So it's a little bit more general.
If somebody hasn't got a written, signed power of attorney, and they're still controlling their assets, so you know she's trusted, you know, a son or a nephew or whatever it is, or a niece, and said, you know, here's my bank account, here's the number, this is, you know, all my whatever I'm getting, it goes in there, and you control it. In that situation, you know, if they, you know, they are not able to make the decision, but this one person's got the control, what happens then? What happens with the rest of the family?
Well, that's a difficult one, because if that person's given consent,
Yeah.
and they've given over passwords, bank cards, PINs, that makes it very difficult to establish that that person has made decisions and didn't have the authority to make those decisions. So it makes it a little bit of a grey area.
Right.
But if that person had a lasting power of attorney, and remember, as an attorney, by law, you have to make decisions in the interest of the person who's giving you the power of attorney. So you can't just have access to somebody's bank accounts, have £10,000 in there and decide to spend £3,000 and go on holiday.
Right.
You have a responsibility to that person. You can be challenged if you make decisions that aren't in that person's interest at all. But one of the things I also want to say is that the lasting power of attorneys that you enter into, these cost to register at the Office of the Public Guardian £82.
£82.
£82
That's
each.
all. That's all.
For each of them.
Yeah.
You can fill them in yourself, or you can go to a solicitor who may charge £400 or £500 plus VAT to actually do all the work for you and monitor and make sure it's registered.
You're doing yourself out of a job there, possibly.
Well, I'm trying to act in the best
if you're
interest.
competent, yeah, if you're competent,
Because it's
you might want to do
it's
it.
not too difficult to complete, but if you miss a section on here, it will be rejected and sent back,
Right.
and you can't redo it. You'll have to make a new application. So it's best to get someone to do it who knows what they're doing. Now, compare that to trying to get some sort of power of attorney or some sort of legal right to actually on behalf of your mother, who now has dementia. She's unable to give instructions. So then the recourse for that is applying to the Court of Protection, getting medical evidence as to what that person's medical condition is, filling in form after form after form, and you would have to make that application. It's going to be complicated. You would need a solicitor for that, and the cost of that could be anything between £1,500 to £2,000 plus VAT, simply because you haven't acted on something like this sooner. And then that can take up to 8 months, 12 months, however long it takes to register at the Court of Protection. Much more complicated, lengthier, more expensive, whereas these forms, you can download them from the internet, start filling them in, you can do them online, pay the fee, which is £82 each. So if you just compare the two situations, why would you want to leave it to, to that extent?
It's not just the issue about the money, is it? It's the issue about making sure that in the event that something happens to you, that your wishes and your desires are actually fulfilled. You know, because you don't want to be, you know, finding out at some stage that, you know, you had a period of incapacity where you could not make a decision for yourself, and during that period some of those people that you trusted or you loved had usurped, you know, the rights of other people as well. Because greed is one of the most nastiest things that, you know, in human nature. And we know, as Nasreen said, and I know for a fact, that there are many, many examples that when something like this happens, there are always somebody in the background who's trying to find the easiest way of inheriting whatever they can to the maximum capacity. There are many, many families where, you know, they work very closely together and they share everything the way either Sharia compliant, or in most cases, inshallah, they do, or whatever the instructions in the person's do, either if they made a will or they've left instructions with somebody they want to decide. But just to make sure that, you know, nothing untoward happens, that everything that you wanted while you're alive, you know, is followed through. These two documents are absolutely vital, with the will as well,
with the will,
isn't it?
Yes.
So there's 3 documents that you need to be looking at. There's the will, which is the most important one in your case. And again, as Naseem says, to make sure that the will is written properly and competently, either you can do it yourself, but you want to make sure absolutely sort of watertight, that you go to a competent solicitor who will then advise you. And you said the fees for that could be up to £400, did you say?
£300-400 plus VAT.
Okay. And then when it comes to these lasting or living power of attorneys, again, these are, and a lot of people may think, why are we talking about this? But just think back. How many people do you know who one day, mashallah, they were very, very, very healthy and living and enjoying life, and then suddenly they may have had a stroke or something else or an accident, and they've become incapacitated. They cannot walk, they cannot talk, they cannot hear, and they cannot even make any decisions for themselves. And in that situation, the family may find themselves in a terrible situation about trying to sort out their medical care or aftercare. If they discharge from hospital, for example, do they go into a home? Is somebody going to be looking after them? Are they, what sort of care workers were they going to, who's going to provide the care working solution for them, etc. And these are, some really important issues. And I'm sure there's everybody out there who would have come across a similar situation. If not in their family, then they'll know somebody else who's gone through this unfortunate incident. And similarly with the finance as well. So in terms of, getting, I mentioned property trust. Is that something that you would be able to sort of share about property trust, where people can put, like say, 4 people can be named, with land registry? So is there anything you can explain on that, please?
So say, for example, there are 6 people, for example, who have contributed to purchasing a property.
Right.
The land registry will only allow 4 names.
Right.
What happens to the other 2? So the 4 people who are named at the land registry will enter into a declaration of trust.
Right.
They will name the other 2 parties, and they will say what they're entitled to.
Right.
So, for example...
But what about if a father's bought a property or a mother's bought a property, and they're the sole owners of the property, and they want to make sure that, the other siblings, say their children, say there's 3 children, and, they want to make sure that they get a share of the property equally. Is that something that property trust can provide?
I would advise they make a will for that.
Right.
But a declaration of trust also sets out instructions and wishes. So if somebody wants to leave a property to their 3 children, they can name them on the declaration of trust, which can then be registered at the land registry.
Right.
But I would prefer a will for that.
Because one of the reasons Mrs. Ali obviously mentioned something, something triggered in my mind is, in the event of a person becoming ill and they need care, right, and they have to look for either local authority care or something like that, they will take a charge on your property if you can't pay for the care costs. And therefore, if they take charge on the property, what they will do is they'll provide you with the carers, and then they will sort of take the property, and they'll sell the property. I mean, the simplest term is they will sell the property, take the cost of the care that has been incurred. And if there's anything left over, then they'll give it to the inheritors. But if property trust because the property will be named on 4 people, for example, they each have a percentage, 25% share. So the one person will only have 25%. Yeah. If that person happens to be the father or the mother, then the council can only take on the charge on the 25%, as long as it's been done a long time ago, and not that intention. Well, now, I know there's quite
limits.
a bit.
So the local authority will look to see what the value of the property is. So if a property is in 4 names, well, those 4 people are all legally entitled to a quarter each. Right. So you look at the value of that share. So there are limits. So it's not just a case of if you have a property that's worth £50,000 and there are 4 people who are named as proprietors, or even 3, that the local authority will do that. It depends on the value of the property and then what kind of care is being given as well. But again, another area that's not really looked at by lots of people out there who then eventually need care.
But I think one of the things when I was talking to one of the experts around this issue, and we can come back on this inshallah someday, is that the local authority will look at your intentions as to why did you put your property in a trust. Did you do it deliberately to try and overcome any care cost? But if you've done it while you were healthy and you were well and with the good intentions that you want to make sure that the property is protected for your siblings or your brothers or your sisters, then that might help you in the long run. But inshallah, we'll come back to that. But coming back to the finances, I mean, what can you include? I mean, is it just cash? They might have it in the home or in the bank, or can you include other assets as well?
Is this for a will or for power of attorney?
The power of attorney.
So the power of attorney is just a general power of attorney. It doesn't refer to anything specific.
Right.
So this could be, a lot of the times it's to do with the banks.
Right.
So say for example, you have an elderly mother, she doesn't speak English and she's very ill, but she has a bank account and you need to contact the bank for whatever reason. They will not speak to you unless you have a power of attorney.
Right.
A really simple example. Remember we came across this a few weeks ago?
Yeah.
So in order to access your parents' bank account, or even I've had a nephew who entered into a lasting power of attorney for finance for his aunt because she didn't speak English.
Right.
And she needed some help, so he entered into one of these so he could just simply speak on her behalf with the bank.
Right, yeah.
So it's generally for things like that, but also for, it could be to do with your bills, selling or buying a house, your investments, bank accounts. It covers a whole general, lots of different areas.
Right. So all the other assets they may have, like you said, gold, for example, they would be in the will rather than...
Generally in the will rather than in a power of attorney.
So it's purely financial.
It's purely
financial, yeah.
To make decisions, whilst you're still here, you may need some help. You still have sound mind, but you may need some extra help.
All right. So again, this is something that you want to consider, I think. Do you want to make sure that, mostly this is going to happen when people are nearly the end of their life. Sometimes it happens when they have an accident or sudden trauma in their life, and out of the blue they're struck with a stroke or something like that. Do you want to make sure that everything you worked for all your life, that you built around you, is protected to the best of its ability, and that your desire has always been to be fair to members of your family, that happens in those circumstances, and therefore the lasting power of attorney, both in terms of financial matters as well as in terms of the care issue, the health issue, are absolutely vital documents. Now, coming back...
Can I just add one thing to that?
Go on.
We think about making a will when we're elderly. We think of power of attorneys when we're elderly.
Oh, yeah.
I made my will when I was 23 years old.
Oh, wow.
Because you don't know when you're going to pass away.
Exactly.
And especially if you have young children, you can specify who you want your guardians to be. So that could be, 20-something years old or 80-something years old. So this isn't specific to an age group. This is looking after your finances and your affairs, whether you're 30 or 70 or 90. So you could enter into a lasting power of attorney at any time. You can make a will at any time as long as you're over 18 years old. So these things are just putting things in order, even from a very young age. I
think that's a very important point. And the Prophet ﷺ, peace be upon him, encourage people to make sure that they put everything is in a contract, it's written, so there's no confusion at the end of the day. The first contract ever written anyway in the world that is recorded was done by the Prophet ﷺ in order to give examples to others as well as the generations that were coming forward and ahead in future. So again, Nasreen is absolutely right. You don't have to wait till you are in your 60s or 70s or 80s. These things need to be put in place as soon as possible in order to make sure that your wishes and your desires. And one of the other things I've learned in my lifetime, and I deal with a lot of businesses, is that we as a community are very, very bad at succession planning.
Yes.
Right? And it goes back to the point that, the father thinks, Bada beta hai, he'll deal with everything. And, sometimes greed takes over and the young people feel left out. And it's important that you do this at the right time, so that everything is, there in black and white for people to be able to deal with when the time comes. We're not saying be morbid, but what I'm saying to you is be prepared. And also, this will be good for your children as well, because there will be no squabbles, between them. And this is something that, I'm saying to you is sunnah. Now, the issue about the will and Sharia compliant, and as Mrs. Ali said, there was issues about who gets what under Sharia compliant, Sharia law, and who would get what under the civil law. is a matter for the families to discuss and decide. But again, if somebody wants to come to you and say, I want a Sharia compliant will, right? And you said, it will have a basis in law anyway. When we say Sharia compliant, do we have people with the expertise to be able to sort of go through the complicated formulas, right?
It is complicated.
It's very complicated,
yes.
I know. Yeah, because then obviously, if there's the cousins, like you say, or nephews or brothers or sisters, and my uncle didn't have any kids, so when my father passed away, or my grandfather passed away, obviously he had an inheritance from that, or his wife did, my auntie did, and again, these are complicated issues. Do we have that capacity?
Yeah, there are solicitors who specialise in Sharia wills,
right?
And you should speak to a specialist, because when you're dealing with Sharia compliant wills, everybody has a share. You've got to be so careful on who that relation is. So Islamically, if you want to do a will Islamically, what share does a mother have, a sister have, a daughter have, an uncle, a nephew, a brother. So you've got to be so careful, what is it that you actually want? Whereas with a normal will, you can specify, well, I have 4 children, I want 4 of them to have equal shares. It's really simple and easy. Right. So you've got to be so careful. So something you may not have intended, you may accidentally intend.
Well, exactly. And one of the things I've learned recently is, if there are siblings alive and the parents are still alive and they know that they're going to get a share of the parents' inheritance, whatever assets they are, while they're alive, they can actually make a decision that they can have the equal share between their brothers and sisters. I wasn't aware of this, but that is something I learned very recently. That you don't, while they're alive and they make a joint decision, that they could have an equal share rather than having the 2/3 or 3/3 or whatever it is, and that is allowed in Sharia as well. But you might want to get that qualified by some ulama. Thank you very much, Naseem. Thank you for coming. Thank you for giving your time. I hope you found that today's episode of some interest. I certainly learned quite a lot, and I hope you have, because as I said, this is an issue that is really grappling our community, and it's causing huge problems and frictions and some devastating after effects within families themselves. I would encourage you to go online, look at the stuff that Naseem has shared with us, and inshallah you'll benefit from it. In the meantime, take care. Assalamu alaikum wa rahmatullahi wa barakatuh. May Allah be with you. Remember us in your du'as. Take care. Assalamu alaikum wa rahmatullah.